Good morning, everyone. It's an honor to welcome you all today to our first webinar this morning. I'm going to start by introducing myself. My name is Maria Rafaela. I am a Brazilian lawyer. I have a postgraduate degree in business law here from FGV São Paulo, and I'm a current LL.M candidate at Columbia Law School. Today, we're going to have a panel with three esteemed guests. We were going to have Adriana too, but Adriana had a problem and won't be able to join us here today. But I'm going to start by introducing the panelists. First, we're going to have Luciano Timm, my former boss. It's an honor to introduce you, Luciano. Luciano is a renowned professor of law at FGV São Paulo and a founding partner of Carvalho Machado e Timm Advogados. He holds a PhD and a master's degree from the Federal University of Rio Grande do Sul, along with an LL.M from the University of Warwick. Luciano's extensive experience as an arbitrator and his postdoctoral research at the University of California, Berkeley, make him an invaluable resource in our conversation today. Next, we are pleased to have John Fellis, an independent arbitrator with over 3 decades of experience in international dispute resolution. Until December 2020, John was a partner and co-chair of the International Arbitration Group at Hughes, Hubbard & Reed here in New York. John's academic achievements include a BA in law from the University of Durham, as well as both an LL.M and an SJD from Harvard Law School. He is also an adjunct professor at New York University School of Law, teaching international arbitration. Joining us also is Harry Burnett, a partner at King Spalding with over 25 years of litigation and arbitration experience. Harry specializes in international commercial and investor state arbitration matters, and he advises numerous Brazilian clients. Harry is a fellow of the Chartered Institute of Arbitrators, and he received his BA from the University of Notre Dame and his JD from Vanderbilt University School of Law. So here are our three distinguished speakers. It's an honor to be among you today. I have no doubt that your expertise will provide very valuable insights for our guests today. And to our guests, we will have a Q&A session at the end. So in the description of the YouTube video, there's a link and you guys can send questions for the panelists. And in the end, we'll have a time to answer questions. And before we begin, I will just read a brief disclaimer that was requested to me by FGV. We would like to emphasize that the statements expressed by members of Fundação Getúlio Vargas staff and by guests who participate in events and online webinars represent exclusively the opinions of their speakers and not necessarily the institutional position of FGV. We also emphasize that all of those present agree to participate in this event spontaneously and that they authorize the use of their name, voice, and image, in addition to assigning the copyrights related to their exposure for this webinar, which will be available on FGV's official channels. To continue with this transmission, FGV asks that the guests express their agreement by verbalizing or signaling their understanding. Okay? Perfect. So we're going to start with Luciano. Luciano's going to make our opening remarks, and then we're going to have a discussion about Brazilian and American practice in international arbitration. Luciano, please, you have the floor.
Many thanks, Maria Rafaela. I'm very glad to be with you online again. It would be better if the three of us, Harry, John, and you, and unfortunately, Adriana couldn't join us, then we would be more than the three, or in my case, 4 of us. It would be better if we were, present in São Paulo, Rio, or even New York, where you guys are right now. But I think the pandemic was horrible, but brought us those tools to work online. We got adapted and it's efficient. So it's a way to bring great practitioners such as those we have today. It's not my case, but at least our invitees are. And I think it's a great achievement for us to start with this, and we're having this first one, Maria Rafaela, but I hope you and other students in the US could help us to have more of this. It's important to have those exchanges between Americas. I'm here today much more to listen, to learn, and also maybe to bring some questions as a Brazilian who, see things from the US from a different perspective, especially having studying in Britain and the US. So, sometimes we classify as common law countries, but they are very different in terms of legal practice, such as Brazil. It's far away from the civil law from Germany, etc. And I believe Brazil and the US should work more. And I think the end of what I hope is the end of the pandemic will put us even more together to discuss the case here, discuss arbitration, international arbitration, but also domestic arbitration. We have many events in which we participated together in the past, but it's the first one that I'm, recuperating the time after, again, the pandemic, and it's good to have this, and probably we're going to have something present as well. Brazil is in a situation in which arbitration was seen as a case of success, but now it's paying some price for its success, and it's in a way under siege. It's under attack lately. And it's good to have, the view also from foreigners, because then we might see things clearer without being involved. And I think this distance can help us from an academic and professional standpoint. So since you already introduced Maria Rafaela, our panelists, I will ask John to start, and then we can from then start our discussion, and of course Harry will join as well and make a presentation. So please, John, more than welcome, and very happy to be here with you guys.
I think you're muted, John.
The rule we should have all learned during the pandemic: remember to unmute yourself. Which was
brilliant, though.
I immediately forgot, and yes, and what I said was actually brilliant, but I don't remember it. So let me just begin by saying it's a real pleasure and honor to be here, and to see you, Luciano. It's been a long time, and to see Harry, it's also been a long time. What I'm going to begin by doing is to give a very broad overview of U.S. law on arbitration, and sort of almost from 10,000 feet above, just to give you an overall sense of it, and then we will drill down on some specific issues. I'm going to, after the overview, discuss a couple of very recent Supreme Court cases from this year, U.S. Supreme Court cases from this year, just to give you a sense of what's going on in the U.S. With that, let me just begin. U.S. arbitration law is actually a complex combination of federal law and state law. As you know, I think everyone knows, the U.S. has 50 states. Each state has its own independent state law, but there's also a federal law that sits on top of it. When it comes to international cases, as a general matter, it is federal law that will govern. There occasionally state law may be relevant as well. I don't want to discount it, but I'm going to focus on federal law for the most part, and there may be some variations in state law, but generally it will be federal law that governs. The federal law in the United States is the Federal Arbitration Act. It's a very short act, and it was passed almost 100 years ago, in 1925. It has barely been changed since. It was changed once to incorporate the New York Convention, once to incorporate the Panama Convention, and once very recently, a couple of years ago, and it's a change I will come back to. But the result has been that US law has really, the statute has not moved with the times. Other countries revise their arbitration laws regularly. England right now is in the midst of revising the Arbitration Act of 1996. It is likely that the new law will be passed in 2024, next year, and it will, address things that have come up in the last 30 years. There's going to be particular provisions dealing with, for example, an arbitrator's duty of independence and impartiality, which wasn't in the prior version of the Act. The US law, the US federal law, as I say, is very short. And because of this, many issues that in other countries are addressed by a statute, such as basic things like the separability doctrine or the doctrine of competence. In other countries, those are the product of statute. In the US, they're the product of case law. They're the product of judicial decisions. And in a common law system, as you know, there is a hierarchy of courts, and the courts higher in the hierarchy bind the lower courts. The highest court in the United States is the US Supreme Court. And in recent years, it has made many rulings on arbitration. It seems very interested in the subject. And when the Supreme Court makes a decision, it is binding on lower courts. Now, one reason there has been no change or no significant change to US arbitration law stems from the fact that there are two very dominant opposing views on arbitration in the United States. One view comes from what I would call, or what is regularly referred to as the plaintiff's bar. Those are lawyers who regularly represent plaintiffs and who sue big business for, among other things, personal injury, representing consumers or employees in class action. And they hate arbitration. They much prefer to be in court. Why do they hate arbitration? Why would a plaintiff's lawyer hate arbitration? Because the alternative to arbitration is to litigate the case in court, and in the United States, civil cases are tried to a jury. And juries tend to award more money than arbitrators as damages. One of the first cases I ever handled when I was a very young lawyer, and I was very low on the totem pole, was a case when I first started to practice in the United States, was a case that originated in state court in Alabama, Alabama being a state in the South. There was an allegation of mortgage fraud, and it was a $15,000 loan. And it was an allegation of fraud in connection with this $15,000 loan. And the jury awarded $6 million based on that fraud. Having found fraud, they awarded $6 million. My firm was brought in to handle the appeal. We didn't handle the lower case. And it was an eye-opener for me, because in handling the appeal, of course, you read the transcript. And one of the things that was in the transcript was the closing argument of the lawyer representing the homeowner, alleging that this mortgage company had committed fraud. And what he said was, and this is not quite verbatim, but more or less verbatim, was, and I want the jury to remember, I want the men and women of the jury to remember that our Savior, Jesus, committed one act of violence in his entire life. What was that? He threw the money changers out of the temple. And then I'm reading the transcript, and then the next line in the transcript, it has jurors, all the jurors, amen. Now, quoting from the Bible may work before a US jury in some parts of the country. It won't work before arbitrators, I hope. You typically persuade arbitrators by quoting the law, not quoting the Bible. But that's why plaintiffs' lawyers don't like arbitration, and they constantly lobby for ways to eliminate arbitration, especially when it comes to consumer disputes and the employment disputes and so on. Because unlike many other countries, the US pretty much has arbitration for everything. There are very few exceptions, actually. You know, in the entirety of the EU, you can have no EU countries. There's no arbitration for consumer disputes. In the US, perfectly normal. That's one side of the divide in the US, plaintiffs' bar. The other side is big business. Big business loves arbitration, in a sense, for precisely the reason that the plaintiffs' bar doesn't like arbitration. And the recent Supreme Court has been very pro-business in its decisions. It has interpreted federal law, the Federal Arbitration Act that I mentioned, to essentially allow virtually every case to go to arbitration. So if a state passes a law that says, if California were to pass a law, for example, that said, you know, no consumer disputes can go to arbitration, the Supreme Court has routinely held, no, sorry, the federal law overrides that, and it says pretty much everything can go to arbitration. And so the only way you can make a change is by changing the federal law, which is not easy to do because you have these two opposing viewpoints: big business that likes arbitration and the plaintiffs' bar that doesn't. The one recent change, I mentioned there was one recent change to US federal arbitration law. It was 2 years ago. It was 2021. It was a law signed into law by President Biden. It was barring the arbitration of sexual assault and sexual harassment claims. And that happened in the wake of the Me Too movement that was not just in the United States, that took place everywhere. And the theory was that sexual predators, men like, for example, Harvey Weinstein, they got away with it for so long because they made their victims sign NDAs and arbitration clauses. And therefore, everything was confidential. Because of the NDA and the arbitration combination, this has now been outlawed. Even if you sign an arbitration clause in that context, if you're the victim of the Harvey Weinstein, you're not bound by it. You can now go to arbitration. And that was the one thing. And in fact, New York was contemplating passing this law, but it would have been unenforceable. You had to change the federal law. It's the only time there's been real consensus in the last 100 years. The other thing that the Supreme Court has done that is very pro-big business is to effectively eliminate the class action. And as you know, and I understand that Brazil has some form of class action device, and not many countries do, but the US has a class action device. It's a very important device for bringing claims, and the plaintiffs' bar obviously loves it, because if a drug company sells a pharmaceutical that many people take and it causes them injury, they can bring up the case as a class action, and therefore the money damages are bigger because you're not suing on behalf of one person. You're suing on behalf of a whole class. Everybody in the state of Florida that took this particular drug, for example. Big business hates the class action for the same reason. It drives up damages award and forces a settlement. Supreme Court has effectively started to use arbitration as a way to eliminate the class action device. It's a very pro-business Supreme Court. And the way it's done this is what big business has started to do was put in an arbitration clause in consumer contracts and a clause providing for class action waiver, the waiver of a right to bring a class action. So the way that combination works, I'll just give you a recent example of a case. There's a company in the United States called AT&T. It provides, among other things, cell phone service. So if you buy a cell phone and you want to switch it on and make it work, you'll have a contract with AT&T. AT&T at some point started to say, if you sign a contract with us, we will give you a free cell phone. If you sign a contract with us. So multiple consumers signed this contract with AT&T with a free cell phone and cell phone service. And the contract had an arbitration clause and provided that you waive your right to bring a class action. When you bring a case in arbitration, it can only be on an individual case. So what happened was this. The phone was said to be free, but in fact, AT&T charged sales tax on the phone, on the value of the phone. It was $30, $30 claim. And so every consumer was charged $30 for signing this contract, thinking they were getting a free cell phone, but they had to pay the sales tax on the value of the phone. There was a couple called the Concepcions in California, and they brought a lawsuit in court, a class action lawsuit in court on behalf of everybody who paid this $30, claiming it was fraud. We didn't know. You didn't tell us. You said we were getting a free phone. We shouldn't have to pay $30. AT&T, of course, said, well, wait a minute. You signed an arbitration clause. Go to arbitration. The district court held, the lower court held, that the arbitration clause was, and this is a legal term, unconscionable, because basically it meant the case couldn't be brought as a class action, because it barred the right to bring a case as a class action. It was unconscionable. It was not fair, and because it was not fair under California law, the governing law, the arbitration clause did not apply, and the case could proceed in court. The Court of Appeals agreed, and then it went to the Supreme Court. And the Supreme Court said, no, this case can go forward in arbitration on an individual basis. So yes, the Concepcions can bring the case on an individual basis for $30. Why? Because an arbitration between two people is very different than a class arbitration. And having class arbitration undermines the entire advantage of arbitration. The problem, of course, is who's going to bring a claim? What lawyer will you find who's going to bring a claim for $30? And this is what one of the judges said in dissent. Justice Breyer said in dissent. The realistic alternative to a class action is not 17 million individual lawsuits, but 0 individual lawsuits, as only a lunatic or a fanatic sues for $30. So with that, let me just sort of switch gears a little bit and just talk about, move a little bit to sort of the international world. US law is very pro-arbitration, and you sort of see this in these types of decisions. Things that could be in court actually end up in arbitration. And, you know, from some standpoints, that's good. I mean, there's a legitimate debate as to whether, you know, consumers really should be required to arbitrate, and most countries don't allow it. But in the US, no, that's sort of the mindset. It's the mindset of the Supreme Court, and they interpret the act. They have final say, and it's very hard to change this act because they're opposing views. The plaintiff's bar wants to change it to eliminate arbitration or to limit arbitration. Big business wants to expand arbitration. So there's virtually no consensus except for this one issue I told you about, inspired by the Me Too movement. So when it comes to international arbitration, what we deal with, what we're concerned about, you find the US is very, very pro-arbitration. It's very pro-arbitration on enforcing arbitration agreements. It's very pro-arbitration on enforcing arbitration awards. Now, there are some wrinkles in all this, as there always are in every country. But as a general matter, you're going to find US courts to be very receptive to arbitration, to assisting in getting it going, to granting preliminary relief, and to enforcing awards. And with that, I want to just discuss 2 recent cases. Well, let me just ask, Maria, should I pause here? Am I sort of running out of time? I don't want to speak for too long.
No, it's great. We have time.
Okay.
I would also, considering that you stopped, I'm going to ask you a question.
Yes, good. Okay, I'm glad I stopped.
Because I had AT&T and Concepcion in my introduction to American law class, so it's great to hear it again. And I would love to know what you thought about Justice Scalia's opinion. Do you think that that was like what really started the pro-arbitration kind of let's call it a movement here in the US?
No, I mean, I think, the pro-arbitration, there has been a sort of a pro-arbitration movement for a long time, actually. I think what you have seen more recently has been a pro-business approach to arbitration. And it's when it comes to the class action, it's very, very interesting, actually, because if you look at the evolution of the law on class action, what you find is a shift. There was a case going back, and I can't remember the date, called the date exactly. It's called the Green Tree case. And actually, the Supreme Court sort of, in a sense, allowed class action in that case. And then it realized that big business didn't like it. So it allowed people to bring cases in arbitration on behalf of a class. And then it gradually realized after that big business didn't like it. And so what happened was it started to pull back on that. And one way it pulled back was it started to enforce class action waivers. Now, to me, Justice Scalia's reasoning is wrong. I mean, basically what he said is, well, the whole point of arbitration is that it's efficient and quick and speedy and uncomplicated. And therefore, in a sense, there shouldn't be class arbitration, because it's so different from an arbitration between two individuals. Class arbitration is a very different animal. So there shouldn't be class arbitration, or at least if there is a waiver of it, we will enforce that waiver. To me, that is a bad argument. It's a bad argument because there is nothing intrinsic to arbitration, to an individual arbitration, that guarantees it's not going to be complicated. I mean, what matters actually in arbitration is party autonomy. I could enter into a contract with Harry and have a very complicated arbitration, where we each have the right to take 20 depositions of 10 hours each, where we each have the right to have document discovery, where we each have the right to, lodge evidentiary objections that you wouldn't normally see. There's nothing intrinsic to arbitration that says it should be quick and speedy and uncomplicated. So I just think it's a bad argument. It is true, in general, arbitration is quick and speedy, but that's not of its nature. What the nature of arbitration is party autonomy. So I think it's a bad argument. But, going on to this point, I mean, what has been interesting recently is this prohibition on class arbitration, bringing a case on behalf of a class arbitration, has actually come back to bite big business. Because what the plaintiffs' law firms have been doing is they have been, it's very easy now when you have word processors that can easily make changes to documents. They'll just draft one complaint on behalf of, say, the Concepcions in this case. And then they'll have some program that just substitutes different names of different individual plaintiffs. And they bringing thousands of individual suits in arbitration. And big business has said there was a recent case against a food delivery company called DoorDash. DoorDash is a food delivery company. If you order from DoorDash, I don't know if it's, they have it in Brazil, or Uber Eats, you may have. It's like Uber Eats. And what you would normally do is you can leave a tip, thinking that the tip would go to the driver. Actually, the tip would go to the company. And so the drivers who were delivering the foods, well, this isn't fair. But of course they had to go to arbitration, but they brought thousands of individual suits, and that overwhelmed the company, in this case, DoorDash. And they tried to dismiss them in court and said, no, we don't want to deal with this. And the court said, no, this is the bargain you made. So in a funny sort of way, it hasn't quite work the way as intended. Sorry, let me stop. It's a very long answer to your question.
No, but it's great, and it makes sense because, of course, for them, it would probably be easier to have one class action for this specific DoorDash case, for example. We have iFood in Brazil. Okay. We don't have DoorDash, but we have something similar.
Got it. So let me just move on then. I'll discuss just two recent cases, just to give you a flavor of what's going on. These are two cases. They actually came one day after another in June of this year. One concerns arbitration at the beginning of the process, so the enforcement of an agreement to arbitrate, and one concerns arbitration at the end of the process, the enforcement of an arbitration award. In order to talk about the first case, it's Coinbase. The case is called Coinbase. Imagine that I sell Harry, whom is blanked right now, but imagine if I sell Harry a painting, and I say it's a Rembrandt, and we have, hey Harry, we have a contract with an arbitration clause, arbitration in New York. But supposing it's fake. We have an arbitration clause. Harry sues me in New York. I go to court and I say, well, wait a minute, we have an arbitration clause. Now, and the court says, yes, you have an arbitration clause, sends us to arbitration. What US law says in that case, if we are in arbitration, if Harry wants to challenge that decision, he has to wait till the end of the arbitration. He cannot appeal immediately. This is pro-arbitration because it means the arbitration can go forward. There's no appeal hanging over it. It's pro-arbitration. Suppose, on the other hand, Harry wins the battle in court. So I sold him a fake Rembrandt. He sues me in court. I say the case should be in arbitration. The court disagrees. No, this goes forward as a lawsuit. Suppose the court says that. I can appeal that. Right? I am allowed to appeal that because this isn't a decision hostile to arbitration. What the law says is I can appeal. What US law, the statute, is silent on is what happens to Harry's lawsuit if I appeal. Because Harry's lawsuit is going forward against me on the ground that I sold him a fake painting. I appeal. I go to the higher court. What happens to Harry's lawsuit? Does it go forward? Or does the fact that I've taken an appeal means it's stayed until the appeal is resolved? Now, the statute is silent as to this. It doesn't address this one way or the other. The pro-arbitration decision would be once I appeal, it stops. And that way, if the appeals court says I should be in arbitration, Harry's lawsuit gets dismissed because it could go forward and Harry could win. And then the appeals court could say, well, no, this should be in arbitration. So what the Supreme Court said was once you appeal, boom, Harry's lawsuit stops. It's stayed until the appeal is resolved. And this is obviously a pro-arbitration decision because it avoids sort of duplicate litigation until it is very clear, until it is finally clear that the case doesn't belong in arbitration. That is what Coinbase held. I won't bore you with the facts of the case. It didn't involve a painting. It involved cryptocurrency. But that is the essence of that decision. Very pro-arbitration decision. The justice who wrote the decision there was Justice Kavanaugh. And the case at the end of the process is called Smagin, S-M-A-G-I-N, Smagin. And this was a case that involved the RICO statute. And the RICO is an acronym meaning Racketeer, Influenced, and Corrupt Organizations Act. And the RICO statute was passed in the 1970s as a weapon against organized crime, as a weapon against, gang bosses and mobsters and gangsters. And it allowed parties, it gave power to the government, but it also allowed private parties to bring lawsuits. And it was used regularly to bring securities fraud claims. And one of the things about the RICO statute, it allows the recovery of treble damages. So if you've been harmed by what's called a certain type of fraud, a pattern of fraud, you need to show a pattern of fraud. If you've been harmed by a pattern of fraud, you could seek treble the damages that you would have got and get attorney's fees. Now, the question in Smagin is, can you rely on the RICO statute to enforce an arbitration award when the person, the loser, the person you're trying to enforce against, has taken steps to try to hide the money, essentially, to try to hide the money? And in particular, it addressed the question is, can a foreign resident, can a foreign citizen, not a foreign resident, a foreign citizen rely on the RICO statute? So what happened in that case was that a Russian citizen in 2014 won an arbitration award in London for $84 million against somebody with can't pronounce his name. I'll just give the first name because it's easy to pronounce. Ashot, who resided in California. And Smagin, having won this, brought an action in California, where Mr. Ashot lived, to enforce the award. Mr. Ashot started moving his money around. He started moving his money through the London office of an American law firm. He created a whole complex web of offshore entities. He transferred money to a bank in Monaco to try to avoid paying the judgment. And so poor Mr. Smagin, 6 years later, still hadn't collected his money, and he brought a RICO lawsuit in California under this statute, saying this is the type of fraud, the pattern of fraud that's captured by the RICO statute. And the question, it went all the way to the Supreme Court. And the question was, could Mr. Smagin, who was a Russian citizen, allege a domestic injury? You have to show a domestic injury under the RICO statute. And the court said, yes, you can. Because he had an interest in enforcing this award in California against Mr. Ashot, who was a California resident, who took steps to perpetrate the fraud in California, and with the aim of trying to stop Mr. Smagin executing on the award in California. The court said that was enough, and he was allowed to bring the RICO claim. Now, we don't know yet what the outcome of that claim will be. Maybe he'll win, maybe he'll lose. I suspect by the sounds of it, he has a pretty strong case. And so he got this $84 million debt judgment. There's probably interest on it now that's probably not insubstantial. And he can now seek 3 times that amount on the basis of the RICO statute. Very pro-arbitration decisions. Let me stop. Now I'm done. Thank you.
Thank you, John. That was great. I think Harry can start now, and then in the end we will open for questions, so then we can get back to you and get back to Harry too. Okay. So Harry, please, you have the floor.
All right. Thank you, Maria Rafaela. I'm going to talk about 2 issues. One is recent developments with U.S. courts enforcing arbitration awards annulled at the seat of arbitration, and 2, recent developments regarding arbitrator disclosures in the United States, which is something that I'm sure Luciano and probably Maria Rafaela will have some perspective on because of the activity in Brazil related to arbitrator disclosures, which in my view seems to be getting out of hand. But I think it is actually in the United States too. But let's first talk about the enforcing of arbitration awards when it's been annulled at the seat. I'll go back to 2016 to a case called Camisa versus Pemex, where the Southern District enforced an award annulled at the seat, which was Mexico City. Camisa, which is an affiliate of Kellogg Brown and Root, KBR, obtained an award against Pemex in an ICC case seated in Mexico. Camisa brought an action in New York for recognition and enforcement, and Judge Hellerstein recognized the award. And I named the judge by name because he's quite a character. I went to see some of these proceedings, and he comes up actually in the second part of my talk. So Pemex moved to vacate the judgment because it had been set aside by a Mexican court. Now, because of the annulment, the Second Circuit initially ordered the judgment vacated and remanded to Judge Hellerstein. But Judge Hellerstein again confirmed the award. He found that no deference was owed to the Mexican court because it violated fundamental principles of due process. The court in Mexico, when considering a huge $300 million award against Pemex, annulled based on the retroactive application of a regulation stating that Pemex could not be subject to arbitration because the case dealt with administrative law issues. Now, this time when Pemex appealed, the Second Circuit affirmed the district court's decision to confirm the award. This was the second U.S. court to recognize an award annulled at the seat. And as many of you probably know, the language of Article 5 of the New York Convention, well, actually here was the Panama Convention, which is virtually identical, states that the court may refuse enforcement or recognition if annulled at the seat. And here, that's exactly what happened here. So the U.S. approach generally has been to consider the principle of comity in analyzing the question. Comity is the respect or deference to decisions of foreign judiciaries. Now, Hellerstein held that, well, wait a minute, but what happened in Mexico was not something that deserved any deference in the court's eyes. Here, the Panama Convention applied, which applies to the members of the Organization of American States. The district court, Judge Hellerstein, concluded that the may language meant that it had discretion to recognize even the award, even though it was annulled at the seat. Other U.S. courts have come out differently and have refused to recognize awards annulled at the seat. There's a case called Timorio versus Electranta. The D.C. Circuit denied recognition of the award, stating that comity meant that an annulled award could only be refused recognition where the foreign judgment violates basic notions of justice accepted in the United States. The U.S. court with Camisa found that the case raised issues of fundamental fairness in public policy. Now, being basically the retroactive application of a regulation passed, that Hellerstein just couldn't get his head around that and found that was just too much. Now, the Second Circuit reiterated the importance of comity, and the final award must be enforced as a matter of public policy. However, it found that the language in the Panama Convention gave the court discretion, and that district court had not abused its discretion in recognizing the award. And it also found that Pemex waived any jurisdictional argument, that the Mexican court's retroactive application of a new law was repugnant to U.S. law and was unfair. And if it was recognized, it would basically leave Camisa without any forum to pursue its claims. So there's another recent development, a 2023 case called Compañía de Inversiones Mercantiles versus Grupo Cementos de Chihuahua, where a Bolivian controlling shareholder in Bolivia's largest cement company petitioned for confirmation of an award against a set of related companies. The U.S. District Court in Colorado confirmed the award. The Mexican companies appealed to the 10th Circuit Court of Appeals, which also affirmed. The award was then invalidated by Bolivia's highest constitutional court and vacated or annulled by a Bolivian trial judge. The District Court of Colorado denied a motion by the Mexican companies to vacate and ordered the Mexican companies to turn over assets. The Mexican companies appealed, and the 10th Circuit affirmed on 3 principal grounds. One, that the district court was permitted to consider whether or not to enforce the Bolivian orders that and whether that would violate U.S. public policy based on previously recognized award. The district court was correct in reading the permissive or discretionary nature of the New York Convention on matters of annulled awards, making the court free to recognize or refrain from recognizing an award based on the may language that we discussed. And 3, the Mexican company's attempt to try to prevent a U.S. court from reviewing whether U.S. public policy had been violated was illogical and impractical. So as a result, the court concluded that when a court has been asked to vacate an order confirming an arbitral award that has been later annulled, it may balance against comity considerations. 1, whether the annulment is repugnant to U.S. public policy, or 2, whether giving effect to the annulment would undermine U.S. public policy. So although the district court may have found that the 2020 Bolivian orders were not repugnant, it did not legally err by considering whether giving effect to those orders through vacatur of its confirmation judgment would offend U.S. public policy. Now, there's another case from 2022 called ESSO Exploration Production Nigeria Limited versus the Nigerian National Petroleum Company. The U.S. District Court in New York refused to enforce an award that had been annulled in Nigeria. It held that although the U.S. courts could enforce an award that was set aside at the seat, if the judgment setting aside the award is contrary to U.S. public policy, the public policy exception is narrow, available only in rare circumstances, and the standard is high and infrequently met. Now, the Second Circuit agreed and said, and I think this is important, on the present record, ESSO has fallen short of its burden of showing that this is one of those cases presenting extraordinary circumstances that are repugnant to notions of justice in the United States, and held that ESSO's argument sweeps too broadly to compel the outcome that ESSO desires here. So where are we in the United States? I think it's a basic proposition that a U.S. court can enforce an arbitration award that was annulled at the seat, depending on the circumstances. In my view, it's extremely important to granularly explain to a U.S. court the circumstances under which the case was annulled in the seat of arbitration. Obviously Judge Hellerstein, based on the circumstances, all the circumstances, found that the Mexican court, its annulment was, contrary to public policy, repugnant, et cetera, which it certainly was. Now, I just wanted to raise something, and I know that Luciano knows a great deal about this, and I think Adriana may have spoken to it, but as I understand it, in Brazil, you cannot, and correct me if I'm wrong, enforce an arbitration award that has been annulled at the seat of arbitration. And as I understand it, in a leading case from December 2015, the STJ unanimously ruled that no recognition may be granted to an arbitral award set aside at the seat of arbitration. In the decision, the STJ concluded that considering that the recognition process aims only at allowing the foreign arbitral award to produce in Brazil the effects therein contained, if those effects are no longer exist due to annulment at the seat of arbitration, there's nothing to recognize or to enforce in the national territory of Brazil. Now, such decision, as I understand, and when I stop, I may be corrected by Maria Rafaela or Luciano, but took into consideration Article 5.1e of the New York Convention, Article 5.1e of the Panama Convention, Article 38.6 of the Brazilian arbitration law, and the STJ's internal rules, and Article 20, Las Leñas Protocol. Now, as I understand it, Article 38 of the Brazilian arbitration law expressly states that recognition may be denied when the respondent to the application demonstrates that the award is not yet binding on the parties and that it has been set aside or has been suspended by a court order in the country in which it was issued. And Article 38 says, and I'll say it in Portuguese, somente poderá ser negada a homologação para reconhecimento ou execução de sentença arbitral estrangeira quando o réu demonstrar que, e número 6, a sentença arbitral não se tinha ainda tornado obrigatório para as partes, tem sido anulada ou ainda tem sido suspensa por órgão judicial do país onde a sentença arbitral foi prolongada. So, and please correct me if I'm wrong, but it seems like there's really a fundamental difference in the approach in the United States of enforcing, or the potential of enforcing an award that was annulled at the seat, and Brazil, in which it appears to be mandatory that the courts cannot recognize an arbitration award that was annulled at the seat. And I'll ask Maria Rafaela and Luciano if I'm correct in that dichotomy.
You're correct about the case. I don't remember the facts of the case, but probably there's an additional but important difference, that this precedent is not binding, So, and Adriana's PhD, it's all about the discussion of the doctrine, and of course, maybe a most important difference is that Brazilian civil law system is more doctrinal. So opinions of scholars tend to be used in court. So I would not tell you without reminding the facts that this would be repeated in other cases. But you're right about the case, and the language of the text you have read, and then I would make at the end some comments that why maybe there's such a difference, because I guess it's a difference of a mindset of court. But I know that this expression nowadays it's a little bit overused, but I will make those comments at the end.
Thank you. I agree with you that Brazilian law is much more doctrinal, and I know that John, who's sat in many arbitrations in Brazil related to Brazilian law, has seen the what I would say many cases have almost a tsunami of legal opinions from different scholars, and it's kind of like, and I know that it's an art form in who exactly you pick to make that opinion. So
again, you're right.
So then let me move on to issue number 2, which is disclosures, recent developments regarding arbitrator disclosures in the U.S. There are 2 recent cases that are very important, and and any of you, all 3, may have comments on this after I'm finished. But the first is a Panama Canal case called Grupo Unidos por el Canal versus Autoridad del Canal de Panamá, ICC case seated here in Miami, where the 11th Circuit affirmed dismissal of claimant's application to set aside 2 ICC awards. The arbitration involved a Panama Canal construction project and Grupo Unidos was the contractor. The challenges were made after Grupo Unidos lost about $250 million after 5 years of arbitration, which I think is also, I would say, a pattern that has arisen. So after losing, Grupo Unidos sought wide-ranging disclosures from members of the arbitral tribunal pertaining to possible bias. Now, each member disclosed for the first time he had served on panels in other unrelated arbitrations in which an arbitrator or counsel involved in Grupo Unidos arbitration participated. And Grupo Unidos challenged the arbitrators before the ICC court. I'll just give a little background. I don't want to get too granular, but the Canal Authority, which is what I'll call the Autoridad del Canal de Panama, I'll just call it the Canal Authority, appointed an arbitrator named Robert Gaitskell. Grupo Unidas nominated Klaus von Wobser from Mexico, who many of us know and respect a great deal. The parties agreed then to a procedure for appointing the president, which led to the appointment of Pierre-Yves Gunter. All were confirmed by the ICC. Now, the ICC court agreed that some of the arbitrators, when they were challenged before the ICC court, that some of the arbitrators failed to make disclosures but did not find any basis for removal. Thereafter, Grupo Unidas moved unsuccessfully in the United States District Court for the Southern District of Florida to vacate the awards. The Canal Authority, in turn, cross-moved, as this is the common procedural process, for confirmation, which the district court granted. Grupo Unidas appealed and argued that the award should be vacated or not confirmed under Article 5 of the New York Convention. Now, the court en banc importantly held that, and I found this a little bit strange, that Grupo Unidas would be arguing only under Article 4 of the New York Convention, but the court held that Chapter 1 of the FAA provides the proper grounds for vacatur of an international arbitration awards, whereas the New York Convention governs the U.S. Of international arbitration awards, where the New York Convention governs and the U.S. has primary jurisdiction. So the question to be answered were the following: should the two arbitral awards be vacated under Chapter 1 of the FAA, which governs vacatur, or two, whether they should not be confirmed under Article 5 of the New York Convention? Now, as I said, in what has become all too common, in my view, losing party here, Grupo Unidas asked for additional disclosures of any facts or circumstances that may affect the arbitrator's independence or that could have reasonable doubts as to their impartiality. It asked each of them to describe the relationship amongst and between the arbitrators, and with arbitrators in related arbitration matters between the parties, and with parties' counsel in any related or unrelated or pending or closed arbitrations. So the arbitrators did make further disclosures, and then there was a request for even further disclosures. Now, the four disclosures that were found to be relevant to the appeal were that, number one, Dr. Gaitskell, while the first Panama case was pending, served in an unrelated arbitration where they appointed Gunter as chair, but there were different counsel and different parties. So in another arbitration, Gaitskell was involved, and he and the other arbitrator nominated Gunter as the president. Two, while the first Panama case was going on, Klaus von Wobser served as an arbitrator, as a co-arbitrator with Andres Hanna, who many of us know, who served as counsel to the Canal Authority in the arbitration, in the instant arbitration. Number three, several years before the first Panama case began, Gaitskell served as arbitrator with James Loftus from Vincent and Elkins, who was also one of the Canal Authority's lawyers. And then four, since 2016, Gaitskell served as arbitrator in an unrelated arbitration in which a different party, represented by Manus McMullen, another of the Canal Authority lawyers in the first Panama case. Now, the district court, and I like this language, frankly, consolidated both cases and directed the parties to file a consolidated motion to vacate and a consolidated cross motion to confirm the awards. The district court found that none of the 3 New York Convention defenses applied to the awards, and it concluded that Grupo Unidos arguments depended on multiple speculative assumptions, each assuming the worst in the arbitrator's character, and that no reasonable person would follow Grupo Unidos down this conspiratorial web. Thus, the court denied Grupo Unidos' motion to vacate and granted the Canal Authority's cross motion to affirm. Now, the 11th Circuit then went through all of the 4 alleged grounds and analyzed them under both the FAA, Article 1 and Article 5 of the New York Convention, and held that we refuse to grant vacatur simply because the people work together elsewhere. The record reveals no evidence of actual bias in the Panama I arbitration, and as to possible bias, Grupo Unidos has established only that some of the arbitration's participants were otherwise familiar with each other, and familiarity due to confluent areas of expertise does not indicate bias. We affirm the order of the district court denying the application to vacate. So the court analyzed and rejected each of the Grupo Unidos defenses to confirmation under Article 5. That recognition would be contrary to U.S. public policy was unsuccessful argument. The tribunal was not in accordance with composed in accordance with the agreement of the parties, also unsuccessful. Grupo Unidos was not given proper notice of the appointment of the arbitrators. All those arguments were unsuccessful, and the 11th Circuit accordingly affirmed the district court's order denying the application for vacatur and confirming the arbitration awards. So obviously that's an interesting case, and I believe that Grupo Unidos lawyers, after getting what we say in the U.S. schwacked with a big award, went on the offensive to try to annul, to try to attack the tribunal at any cost by making I think it was actually the partial award, partial award request for disclosure, and keep going. And that is a tactic, and John may have some comments on that seems to be pursued with frequency. So another case from 2023 is called Andes Petroleum of Ecuador versus Occidental Exploration and Production Company. Andes Petroleum moved to confirm a $500 million arbitration award arising from a contract dispute involving hydrocarbon development in the Ecuadorian Amazon. Occidental Petroleum moved to vacate, citing alleged impartiality of its own party-appointed arbitrator, Rob Smith, who I think many of us know used to be Simpson Thacher, really wonderful guy. And during the selection process, Smith disclosed that he knew Andes Petroleum's lead counsel, Larry Shore, who we all know and respect as well, from attending arbitration conferences. So he said, look, I know Larry Shore. We're part of the arbitration community. Have attended a lot of conferences together, et cetera. Now later, Smith was appointed to serve on an ICC tribunal in a separate, unrelated arbitration. Shore was appointed to serve as president of that tribunal. Neither disclosed their appointments to the respondent Occidental. Merits hearing was held in the arbitration between Andes and Occidental, and a unanimous award was issued in favor of Andes for $400 million. Now, Andes moved promptly to confirm. Occidental moved to vacate the award under the sections of 10A1 through 4 of the FAA, alleging impartiality of its own arbitrator, alleged imperfect execution of the duties of the panel. And Judge Hellerstein, as I told you, we would hear from Judge Hellerstein again, the same judge who recognized Comissa's award despite it being annulled at the seat, held that under the FAA, the party moving to vacate an arbitration award has the burden of proof, and the showing required to avoid confirmation is very high. He then proceeded to analyze the alleged grounds to vacate under Section 10A of the FAA. First was alleged fraud, corruption, undue means. He rejected this, saying that fraud had not been adequately pled, and also it could have been discovered because there were, on at least one website it was published that Smith and Shore were serving in that ICC arbitration together. Arbitrator partiality. He rejected this argument, saying that there was no showing of evident partiality. He said courts find material relationships where arbitrators have undisclosed pecuniary interests or close familial relationships. And he cited Scandinavian Reinsurance versus St. Paul Fire and Marine, which is an important case in New York, which held that the fact that two arbitrators served together in one arbitration at the same time they served in another arbitration is not, without more evidence, that they were predisposed to favor one party or the other party. So they held that respondents' argument of evident partiality was mere speculation. Arbitrator misconduct. The court held that respondent failed to show it was denied fundamental fairness. And finally, the grounds raised was that arbitrator exceeded his authority. The respondent claimed that Smith exceeded his power under the parties' agreement to arbitrate and lacked authority not to disclose the Shore relationship. It was held because the tribunal decided an issue within the scope of the agreement and argued a colorable justification. It accordingly denied. So the court decided that the issues were within the scope of the agreement and that Occidental was given a fair shake in all respects.
And in this case, Harry, did they address the fact that the award was unanimous? Because I feel that's taken in account here usually in Brazil.
Yeah, no, absolutely. And I think that's important. And I think it's important in any cases where there are these attacks on the arbitrators, these kind of what I would call kind of guerrilla tactics, which I know that I've seen actually both in the US and in Brazil. So the Second Circuit, this is June 15, 2023, reviewed the decision to confirm de novo, because the decision to confirm was a legal decision, and reviewed the findings of fact for clear error. And John mentioned this earlier, but the Second Circuit cited the strong deference due to arbitral awards and the arbitral process, and held that Occidental speculation that Andes had the opportunity to obtain real-time behind-the-scenes access to Smith does not establish evident impartiality. So in effect, they were saying that that Smith and Shore were sitting in another arbitration, and this is complete speculation, that Shore was, during that interaction, somehow conveying or giving real-time information to Schmidt, or trying to figure out kind of where Smith was, his head was at in the other case. So the court held that Occidental does not allege a material relationship, such as a family connection or ongoing business relationship with a party or its law firm, circumstances in which a reasonable person could reasonably infer connection between the undisclosed outside relationship and the possibility of bias or against a particular arbitrating party. And I quote, non-disclosure of an unrelated arbitration does not appear to have undermined the twin goals of arbitration, namely settling disputes efficiently and avoiding long and expensive litigation. Therefore, the lower court's decision refusing to vacate the award was proper. So I'd like to, I guess because Adriana's not here too, I'd like to discuss a case that relates directly to Brazil, a US case from back in 2015. So despite the fact that these two cases and the case that I'm about to mention held that failure to disclose did not warrant vacatur of the award or justified refusal to confirm, that's not the end of the story. Because if you've got to go take your award that's been upheld at the seat and enforce it in Brazil, for example, you still have a process to go through. Any international arbitration award that you want to enforce in Brazil has to go directly to the STJ for that. So there's a case that I know everybody's familiar with called ASA Bioenergy versus Adriano Ometo Agricola. So in that case, after the award was issued against Ometo for, I think, 110 million or something like that,
Is it on again? I'm not sure. Okay.
Mas onde é o chefe?
Sorry, Harry.
Where's our chief? O chefe?
I'm talking to him right now. I don't know. He's not.
He's younger than John and I. My God, get him back on here.
He's typing. Let's see. He asked me to just like open up for questions and ended up with you guys because he's having problems with his connection. I think he's gonna try to come in to say some closing remarks, but we can continue.
Okay, so the only last thing I'll say about Ometo is that you had a arbitration award seated in New York. There was an allegation after the fact, of course, after the award was rendered or issued, that the president of the tribunal failed to disclose that his firm Debevoise had done legal work for an affiliate of Abengoa or affiliate of the claimant, and that there was a hearing on it. Judge Rakoff, who's a very well-respected judge, questioned David Rivkin on the stand. I read the transcript and then ultimately determined that, look, he didn't know anything about it. He didn't put in the right name. He had no knowledge of this, so it could not have affected his thought process. So, you know, the award was not annulled or vacated. But then the respondent, Ometo, whose I suspect majority of their assets were in Brazil, the claimant went to Brazil to the STJ to have the case recognized and enforced, and that was denied by the STJ on public policy grounds related to the failure to disclose. And in my view, and this is what I think is particularly important, is to me, this seemed to kick off a frenzy almost in Brazil to attack arbitrators and to seek annulment for the most picayune failures to disclose, and also pardon me, there's also, as I understand, an effort to amend the Brazilian Arbitration Act to make it even easier to seek annulment or challenge an arbitrator based on a failure to disclose. That it's I don't know the exact language, but it's that may in some way raise doubt as to partiality or independence. I hope that doesn't go anywhere.
Very subjective.
Very subjective. So that's all I really have, but happy to answer any questions.
Perfect. Thank you so much, Harry. Thank you, John. Both of your speeches were great. I mean, we have many students watching too, so I'm sure that it was a class, a great arbitration class for everyone that's here with us today, for all of our guests. Our guests can ask questions through the link that's on the YouTube description. So I'm just gonna take a quick look here to see if we have any questions for Harry or John. Then I think we can have one or two questions, and then we can close the webinar. Just a second, please. There is a more general question about arbitration in the US. If there are any specific sectors or industries in the US that are showing an increased preference for arbitration over litigation. I don't know if Harry or John.
I'll let John answer, and then I'll give my thought.
Okay.
Well, I'm not sure that I can point to anything in particular. And it's very hard, as an individual, what you see is what you see, and it's very hard to get broad-based statistics. My impression is arbitration is actually growing. I think the one area where there may be some growth is in the financial services sector, banking and so on. Traditionally, banks haven't used arbitration, partly because, the disputes can be very straightforward. A bank lends you money, you don't pay it back, it wants the money. It's a very easy dispute that can be resolved on the papers, and it's often easier to do it in court. But I'm seeing a little bit of growth there. But other than that, I think my impression from where I sit is there's a general growth in the use of arbitration. I'm not sure that I can think of any specific industry. I mean, new industries like, alternative energy, yes, they use arbitration, but so did traditional energy. So I don't know if that would count. But Harry, over to you.
So I think that, you hit on the energy transition and renewables and things like that. I think in general, there's an increase in construction arbitrations. That's my understanding, and that's my feeling, because I think that so many of the energy transition projects involve big construction projects and things like that. That's just my impression. We have several going on right now, and I think especially in the Middle East, where there's a lot of construction going on. Well, that's actually not in the U.S., but if it's seated in the U.S., I just think I think that construction cases are starting to increase in the arbitration sector.
Yeah. And a lot of those are actually driven by COVID, because I think a lot of things got stalled. A lot of materials that were required for construction products just weren't available, and we're seeing some of those disputes now.
And probably supply disputes. I'm sure John has, and I have, advised a lot of clients on kind of what to do for the delays during COVID, because, I think parties during COVID kind of gave each other some flexibility. And now that COVID's over, there's still some hangover from that. And I think there's probably quite a few of those cases kicking around, but hopefully they'll be gone soon, and everything associated with COVID will be gone soon.
Great. And I was just seeing that I got a message here from FGV saying that we had 74 people registered for the webinar, so it's a big audience. We have also a more general question that I think it's more about domestic proceedings, but regarding the costs associated with arbitration proceedings in Brazil and in the US. Do you think that there's a place that cost-wise it's more expensive, or that's what I took from the question?
I don't know, Harry, if you want to have a go at this one. I mean, I'm happy to, I think a lot of the costs, I mean, the main cost of the arbitration, of any arbitration, are the lawyer's fees, right? I mean, that is the most expensive element in any arbitration. You see this as an arbitrator. I see it when I get costs applications. You'll have the arbitrator's fees, you'll have the expert fees, you'll have travel for witnesses, and you'll have the lawyer's fees. The lawyer's fees are the biggest component, and so I suspect, especially if you compare New York to say Sao Paulo, that New York lawyers' hourly rates are probably higher, but that would be my guess. But you may know better, Harry. I suspect you do.
Well, I mean, I agree with what you just said for sure. I think if we're talking domestic cases in the US versus domestic cases in Brazil, I think that domestic cases in the US are much more expensive because many times they're more similar to court proceedings where you've got a lot of discovery, and it ends up, just really racking up the fees. Some domestic cases, you have depositions and things like that. But in Brazil, you don't, and it's very rare to have this, extensive document discovery. Certainly no depositions, and I think that. So I think that's kind of the fundamental difference that accounts for a difference in the cost. But I think I agree with John that attorney's fees tends to be the kicker in any jurisdiction.
Yeah, and I think that's true. In Brazil, we have a bigger difference because the court proceedings are fairly cheap, especially if you're comparing it to arbitration, and you have the normal fees, and then the next big thing would be the attorney fees. So, but if you compare courts and arbitration proceedings in Brazil, there is a huge difference, and I think that this difference is a bit smaller in the US. I haven't had experience practicing in the US, but that's what I took from this year already.
Let me ask a question. My understanding in Brazil is that there are generally no witness statements, that the witness gets on the stand and they're cross-examined at the hearing. So that's probably saves money. It's also, I learned that the hard way because I've had several cases in Brazil with Brazilian arbitrators, and I've had to kind of fight to get written witness statements, which the first time I thought, geez, oh my God, I might not get written witness statements. It was very unsettling, but luckily we got it. But I think that's true, Maria Rafaela, that really no written witness statements in the domestic arbitrations.
No, we don't. And in court proceedings specifically, we are having like the trials. Most of them are online nowadays. And then the witnesses go online from wherever they are. So that makes things a lot cheaper. And in Brazil, it's being very common, like for us to have the proceedings like totally online, even in court proceedings. So I think that also makes things cheaper. And that also, there was a question about technology, and I started talking about that, and I remembered that we have, it's the last question, so I think we can grab this one too. How has technology such as online dispute resolution platforms impacted arbitration processes in both Brazil and in the US? So I think that I already introduced the Brazilian part. It's in court proceedings, but I've seen that being done in arbitration proceedings too, in Brazil, in domestic proceedings, but John and Harry can talk more about the US.
Yeah, maybe I'll start off on this one. I mean, since COVID ended sufficiently that we could convene in person, I've had most arbitrations I've had, in fact, all with the exception of one, people have wanted to convene in person. Hearings have been in person. Now, it doesn't mean technology isn't used. I've had a number of cases where, I just had a case a couple of weeks ago. We had witnesses in New York. We had witnesses in Singapore. Long way to come. And whilst the important witnesses came from Singapore, those who would only be questioned for about an hour, they did it on Zoom. And we're all very familiar with it. And there was very little controversy about it. It used to be the notion of a witness appearing by video was, a big fight between the parties. I want them to come. No, they shouldn't have to come. Now, I think people have become much more calm about it and more willing to accept it. The other big change is, typically case management conferences at the beginning of the case used to be by phone only. I think now we are used to doing them by Zoom, and people very much prefer to do them by Zoom. You get to see it, to see everything. And I think the other change is, you'll have the hearings and maybe a month later you'll have oral argument, rather than make everybody travel again. I think doing things over Zoom has become much, much more acceptable. And easier, frankly. So I think it has impacted things. I think all to the good. As a general matter, I've only ever had one case, the last, probably out of 20 cases, where the parties both wanted to have hearings online. And that was because the witnesses were everywhere. I mean, they were scattered everywhere. And to bring everybody, in this particular case, again, to New York, would have just cost so much money that it made sense to do it on Zoom. But in most of the time, the lawyers on both sides want to do it in person. I rarely had any disagreement about that. But Harry, over to you.
Well, one thing I'll say is I was concerned initially that cross-examination and things like that would be much less effective virtually. But I had two cases. One was a massive construction case that lasted a month. It was completely virtual. I thought that and a lot of this is, I guess, credit to the lawyers, that they had the right technology. They had their exhibits properly, selected and prepared to show the witness very quickly, instead of a lot of fumbling around and things like that. And I found that the chairman and other arbitrators were also able to kind of read the nuances of testimony and the body language of the witnesses. I was very impressed by that. And then we had an M&A case in Brazil where it started out in person. And then on March 12th, we were in the hearing, and actually things started kind of going wacko around the world. And the chairman said, I understand we're in Brazil and everyone likes to, hug each other and kiss each other, to greet each other. But I will now say that everyone must go like this. Hello, oi. And then 2 days later, he declared force majeure, and everyone went to the airport and got out of town. And then we continued the arbitration virtually, and I thought that it was, very, very effective. So that's I think it all depends, and John knows much more than I do because of his sitting in so many important arbitrations, that a lot of it has to do with the parties getting their act together and getting the right technology, dealing with the documents correctly, and making things run smoothly. And there are certain companies that I think are better than others at helping do that. But that's just my view.
Yeah, and people are getting used to it right now. So we already went past through that stage where we didn't really know what to do with the technology and didn't know how to deal with it. So I think that it's really improving. In Brazil, we have in court proceedings, we have in most proceedings, we have a mandatory mediation. Like it's kind of like a small trial, a mediation trial before the court proceeding begins, and that used to be done in person. So we had to go all the way, travel, I don't know, 5 or 6 hours to do that, and usually the parties didn't reach a consensus. So we just went there, we spent 15 minutes in the hearing, and then we had to go back to the firm. So now we're doing that all online, and it's great. I mean, I love it. I'm saving so much time. And I think that these things are coming for good. Most judges back in Brazil, they don't want to change, and now they don't really need to do it online anymore, but they continue because it's so much easier.
I do have a question I think people will find interesting, actually one for John. Have you had situations where one party is demanding in person and the other is saying it should be virtual, and then how does the tribunal handle that?
You know, not since the end of the pandemic. I mean, not since we were able to convene together. I've never faced that situation. I mean, I've had, you know, most cases except one, as I said, parties both wanted to do it in person, and I had one case where both parties agreed not to do it in person. I did have, you know, the fight sometimes when it comes is having, you know, I had a case involving China, and the most important witnesses, the Chinese party, said, well, we'd like to have them on Zoom rather than in person. The other side said, no, we want them in person because we need to be able to cross-examine them in person, and that's more important. And we did order them to come to appear in person because they were the most important witnesses. And I think if one side's most important witnesses are going to be there in person, it's only fair that the other sides are. You know, I sort of generally agree with you, Harry, that you can conduct an effective cross-examination over Zoom. However, other things being equal, I do prefer to convene in person. The problem is other things aren't always equal, right? I mean, sometimes the cost, and this is, you know, traveling for 5 hours for a 15-minute mediation, the cost-benefit analysis, it makes no sense to do it in person. But, you know, if you have a significant case with, you know, a week or two of hearings, then I think it does, you know, and I think most parties want that. I mean, they want the ability to see the arbitrators in person and to see the witnesses in person. And I think it's helpful to the arbitrators as well. I don't
have the cases in front of me, and maybe I'm imagining this, but I think in investor state cases, some states were demanding in person in order to delay things because that was it was kind of impossible. And I think some tribunals yielded to that, and others finally said, we don't care, it's virtual and we're doing it on the date that it's supposed to be. I don't have those cases in front of me, but I think that's been somewhat of a trend. Maybe this is all over because COVID's over, but states demanding that it be in person.
So I think that's it. We don't have more questions. Luciano, I was talking to him right now too. He asked me to thank you guys since he wasn't able to come here at the end. He had connection problems. But thank you, John. Thank you, Harry. It was great. I'm honored to be presenting this panel here with such esteemed guests. And I'm sure that all of our guests here on YouTube also really enjoyed our conversation. It was very valuable, very useful. And I hope to see you guys again. We have the arbitration week next week here in New York. So if you guys are there, I'm going to go say hi. And then we can meet in person too, but it was great. And thank you FGV too for supporting the webinar.
Obrigado. Thank you. It's a real pleasure and an honor. Thank you.
Obrigado.
Bye-bye.